a little background here. Recently, the appellate courts have overturned a case which was DMV against the California DUI Lawyers Association, where CDLA, this organization of DUI lawyers in California, sued DMV over 10 years ago, saying that the administrative per se hearing process was unlawful. Basically, DMV hearing officers, these administrative officers, were acting as both a judge and a prosecutor, which is not the way that the law is set up. It was not fair. It was not following the rules. And basically, finally got a judge, an appellate panel to agree with this. And what has happened is DMV has had to backpedal. And so if you get a DUI in Marin County, we're now dealing with a hearing officer who has a DMV hearing officer who has been through a lot of changes this year. And so what has happened is, at first, DMV stopped doing all hearings for a while to figure out how they could do these fairly in compliance with this appellate court ruling. And then DMV decided, well, we're going to use 2 hearing officers, but we're not going to call them that. We're going to call them an advocate and a trier of fact. And so the advocate would be, put the case forward, and the trier of fact would be the judge. Well, that was not in compliance for many reasons, and DMV probably figured that out. Now what they've done, and we're talking about as of, I want to say September 6th, so just this month, they went back to a 1 hearing officer system. And who knows if this is going to change again. But currently, if you have a DUI in Marin County and you have an attorney who fights these cases, when they're dealing with the admin per se, DMV part of it, the hearing where they're trying to take away your license, the hearing officer will no longer do what they did before, which was that they used to subpoena witnesses, police officers when there are problems with the paperwork, witnesses to driving or to accidents, toxicologists. They're not subpoenaing anybody. At least that's what they've been instructed. And so basically it's going to be a situation where they will be able to see the police report. And these reports, there's something called DS-367, which is signed under penalty of perjury by a police officer. And if what they've signed and filled out is not done properly, sufficiently, if there are glaring errors in it, what they used to do is they just subpoena the police officer, have them clean it up verbally, and have their case. Now, they're not going to be doing that. So there are positives and negatives to this. But if you have a Marin County DUI lawyer who knows what they're doing and who has been doing these hearings for a while, what they're going to understand is what to look for, how to try and avoid a suspension with DMV. And something that you should know if you're looking at this video and reading the transcript of it, is that if we can get, worst case, your DUI in Marin County reduced to a wet reckless, and if we can win your DMV hearing, absolutely nothing will happen to your driver's license, which is huge for most people. So there's a lot more to what's going to be going on with these DMV hearings, and I'll talk more about it in the near future on some updates on this site. But just know now that changes have happened. DMV is in flux, and in Marin County, cases that come out of Marin County, and that does include the entire Bay Area, but actually Marin County cases are heard by the San Francisco Driver Safety Office, and the hearing officers there are under the instruction, and this is based on my talking to the hearing officers and staff there, that there are new procedures. And these procedures may help my clients, my DUI clients, in a huge way. So very important to get a DUI lawyer who practices DUIs exclusively, who understands this, who follows these rules, who does a lot of these hearings, and has been doing this for a long time in Marin County.